Sidharth, Luthra, there will be those who will say that the judges have overreached. That tomorrow the judges themselves appoint themselves. Judges of the Supreme Court appoint themselves. The collegium system is under question, but they are telling everyone else to be independent. How do you respond to that?
So let me answer that as a lawyer. We must understand that this judgment seeks to rely upon an old principle in the Vishaka case, where it said that if there is no mechanism, the Supreme Court can step in, create a mechanism till the legislature steps in. Mm-hmm. Now the Constitution says there can be laws to regulate this, the functionality and the appointments of the election commissioners. But the Supreme Court has perceived that there was a gap, and what's interesting about this decision is there are arguments made both for the case, which was made by the petitioners, and also by the intervener and by the Solicitor General, the additional Solicitor General and the Attorney General, saying that, look, there is a mechanism and the court should not legislate. So the legal question that we need to consider is, should judicial legislation be acceptable? Is it the appropriate method or not? Let me just tell you that while there have been decisions in the recent past 2 judges, 3 judges decisions saying that the Supreme Court can lay down guidelines, but the fact is that in 2002, a 7-judge bench decision was very clear in P. Ramachandra Rao that the courts do not possess the power to legislate. They cannot give directions. That was in the context of laying down timelines for conclusion of criminal trials, that you can't legislate. So that's the legal part. Now, the other interesting thing about this judgment is that it takes into considerations instances of appointment and how certain candidates were considered, the timing, etc. So it becomes a very fact-based understanding. After all, judges are not immune to what happens in the world. They had occasion, obviously, to see the relevant files. They're not immune to what the environment is. Thirdly, I must also add is, the point is, when the Constitution came into being, we've had over 100-odd amendments, but the fact is, we all, opposition and governments in power, parliament in essence, has to get about to do its business to ensure that we have robust, independent regulators, independent constitutional authorities, because that will add to our constitution. So it's not a case of one or the other. The pot calling the kettle black is what I would say, really, because you can't have one party. So today people are lauding the government. The people laud the government, but it's the same parties will have criticized the Supreme Court in an earlier era. The point is, the court has tried to see that there is a issue which it wants to resolve.
No, but you don't believe it's an overreach. Very quickly, you don't see it as overreach. You don't see that the judges are deciding. You might as well give the entire executive power then to the judiciary today.
Rajdeep, I have a concern about judicial legislation, which I raised at the outset. I believe it is not appropriate, and that's across the board. Having said that, there are moments when courts will come forward to point out certain things. I know, but can I to say that there is a lacuna or a gap in the system?
Can I stop you for a moment?
To have happened.